you in your home in the evening of August 20, 1989? Your Honor, I would ask that the prosecutor return to the podium. Is she going to be referring to this diagram? Yes, Your Honor. On that evening, where were you in your home at approximately 10? I was in my bedroom. Can you show us where on that picture that would be? My bedroom is in the back right here, Your Honor, indicating for the record the back where there appears to be part of the house and the pool. I'm sorry. I was not in the guest house. I was in the back of my bedroom is back here. Okay, that's right before the pool. Is that right? Right. Indicating for the record that would be the area right before the pool. Yes, thank you. You can sit down. Now, did you hear a noise that attracted your attention that night? Yes. And at approximately what time did you hear this noise? Around 10:20, between 10:10 and 10:20. Were you alone at the time, or were you with anyone? I was with my son. And did you have any other children at home at the time? My daughter was in her bedroom, which was in the front of the house. And was your daughter there all night, or did she leave at some time? She left. About how long after you heard the sound did your daughter leave? There wasn't a long time period. Do you recall about what time your daughter left your house? I think it was more or less the same time, within a 10-minute span. So about what time do you think your daughter left your home? Do you know? It's been a while and I'm not terribly sure. I think it was around 10:10 or 10. And is that about the time that you heard the sound? No, I heard the sound like at 10:20. And do you recall testifying previously in this matter? Yes. And do you recall testifying previously in this matter that you heard the sounds about 10:10? It may have been that, yes. And now, can you describe for the jury what it was that you heard? It was a series of popping sounds. And when you say a series, can you describe it just a little bit more detail, approximately how many? It sounded like definitely more than 6, might have been 10, 12. And did you hear them all at the same time, or did you hear them in? No, there was a time lag. I thought it was Chinese firecrackers because I heard a series of shots, and then there was a time lag, and then there was another series of shots. And the reason that I thought it was Chinese firecrackers is because the way that I'm used to it is that the fuse runs all the way across, and they pop, and then it takes time for the flame to go down the string, and then it knocks the next row. That's why I thought it was Chinese firecrackers. So your understanding is Chinese firecrackers pop, and then it takes a little time, and it pops again? Yes. Is that what this sounded like to you? Yes. And was your son present when you heard this? Yes. And did you have a conversation about these sounds that you heard? Yes, we went to the phone. Objection, hearsay, if it's going to elicit that. Your answer was yes. The rest will be non-responsive. Your next question, please. Did you call the police when you heard these sounds, the poppings? No. My son picked up the phone and dialed 911, and I wouldn't let him call because I said it was ridiculous. It was Chinese firecrackers. When your son dialed 911, did you, the call I take it, didn't go through, or you didn't make that call? Objection, calls for speculation. I put the objections sustained. The answer is stricken. What happened when your son picked up the phone to dial 911? Objection, hearsay, overruled. I put the receiver down. Did you say anything at that point? Objection, hearsay, overruled. I said to him, why are you calling the police? So he said, they're gunshots. So I said, but it's not gunshots. He said, well, what else would it be? So I said, Chinese firecrackers. And he said, in August? And I said, yes, someone found them left over from July 4 and let them off. So he said, Mom, you're being silly. That's not Chinese firecrackers. That's gunshots. Was that pretty much the end of the conversation? That was it, yes. So did anyone from your house call the police that night? No. At some point that night, did you talk to the police? No, not that night. How about the next morning? Yes. And did you tell them about the sound that you heard? I didn't put the two together until the detective said, did you not see or hear anything? And then I saw my son's reaction, and I realized what he had heard were actually gunshots, not the firecrackers that I thought they were. Did you mention this to the police the next morning? Yes. Did you, when you described it to the police, how did you describe what it was you heard? It was a series of popping and then the time lag and then another series of popping. Now, did you explain to the police about the time lag that morning or at a later time? I don't remember, quite honestly, if it was at that time or at a later time, but I definitely did tell them. And as you sit there now, do you believe that this was probably between 10 and 10:20? Yes. Thank you, ma'am. Nothing further. Thank you. Cross, I have a couple questions. Okay. Let's. 180, 4-voice, 5-minute test. Starts with question by defense. Ready? Officer, do I recall your testimony correctly that you did ask the defendant if there was any dope in the house before you started your search? Yes, sir. It was just before I started to walk into the room. I stopped and I made a casual remark to him. I stated, "You don't have any dope in the house, do you?" in a question form, and he said, "No." Have you ever told anybody that narcotics were just not mentioned until after they were found? I don't understand your question. Have you made the statement to any other person that narcotics was simply not mentioned before they were found? No, sir. You didn't tell Mr. Friedman, who is seated at council table, on any occasion that narcotics simply were not mentioned until after they were found? No, sir. I had several conversations in which he came up to me in Downey Court, and in talking about all these conversations, the last one we had, he disputed our prior conversations and said, I said something different, which I don't recall, and I don't think I said it. I am testifying to the best of my ability to be very honest about it, and that is the way I remember it. Thank you, officer. Nothing further, Your Honor. Very well. Nothing further of this witness, Your Honor. All right. What about excusing him? We would like him subject to recall, Your Honor. I have another one next door, Your Honor. I will be here. Very well. Subject to being recalled on request of either counsel, you are excused. People rest, Your Honor. A defense would call Officer Dorn, I believe it is. Your Honor, do you have the file in front of you? Yes, there is a return on subpoenas. I haven't checked on whether there is a return on Officer Kelly or not. I am just curious. Well, it says proof of service. I served the foregoing subpoena on Detective Kelly by serving the police department, Downey, which was last week, Tuesday. And as I understand, that is kind of a common process. There is one person designated, and he usually sends them out. Beyond that, I have no way of knowing whether or not the person was personally served or whether or not the lieutenant gave it to him or told him about it. I understand from counsel he is in the court building, so if we need him, maybe we can find him. All right, come ahead. You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Be seated and state your name, please. Donald Eugene Dorn, D-O-R-N. Mr. Dorn, would you tell us your occupation on April 14th? Police officer for the city of Downey. Now on that date, did you participate in an arrest of the defendant, Ronald Brown? Yes, Your Honor. In view of this officer's occupation and his participation, we would like to have a ruling that we are calling him under 776 as an adverse witness. Very well. If you say so, I agree. On that date at about 9:30 p.m., do you recall going to 9938 Downey Bridge Road? I don't recall the address, but it was defendant's home. Do you recall what information you had in your possession concerning possible criminal activity at that address? Yes, I was advised by the detective that there was a slot machine at that location. Is that all the information you had? Yes. When did you get that information? I believe it was on a Friday. And the following Monday, the 14th, is that the day you went there? Yes. That was not a week intervening there? No. I might have even been advised by the detective on Friday. I am not sure. It was sometime prior. I was also advised by the detective Englert. I don't know which advised me first. Were you in uniform when you went to the residence? No. Did you have your badge with you? Yes. What happened when you got to the door? We approached the front door. We, meaning Detective Englert and Kelly, approached the front door, knocked on the door. A male subject answered the door. We advised him that we were police officers and conducting an investigation of possible gambling equipment at that location, and requested to speak with a Ronnie Brown, who was the defendant, who was in the room and identified himself as such. We also advised him that we were there conducting an investigation of possible slot machine at that location. He stated there was and showed us the machine. Did you display your badge at the door? Yes. $160. Question by defense. Did you hear Detective Englert tell the defendant what he was there for? Yes. Do you recall his exact words? I believe they were just about the way I stated them, that we had received information that there was a slot machine on the location, and that we were there to investigate it. Now you see the drawing on the board? Yes, I see the drawing. Does that appear to be an accurate depiction of the view from the front door of the residence? Your Honor, for the record, I think we should indicate counsel is talking about Defense Exhibit A. Pardon my interruption. Thank you, counsel. All right. Just to clarify the picture, counsel, do I understand that at the very bottom of the picture, where the lower thumbtack appears, that is really the threshold into the hall? Is that true? I believe that's correct, Your Honor. The only thing that I do not remember about this particular, yes, I do now, yes, this is accurate. And the point where the thumbtack is the threshold? Yes, in that general area. Can you point out where the defendant was when you entered? As best I can recall, he was somewhere in this location in here. There is a couch, there was a couch, I believe, across this way. He might even have been sitting on the back of the couch. I am not sure. However, he was inside the hallway portion near the threshold. I am sorry, officer, I didn't follow you. You said he was back in the back by a couch? Well, he could have been. He was in this area here, as I recall. Now, there was another subject, a female subject, I believe, in there. I am not sure which one was where. However, he could see us from the door wherever he was. I don't know his exact location. I could see him and he could see us. Where was he when you first spoke to him? I didn't speak to him. Detective Englert did. He identified himself as Ronnie Brown, and he approached the threshold at that time. It's where we showed him our badges and advised him why we were there. You had not crossed the threshold prior to his coming up? No. Where was the first point from which you could see the slot machine? It was after we entered in approximately here. Now, this is a doorway through a bar, and I could see across the top of the bar. Sitting in the back hallway, I could see the top portion. Do you recall anybody advising Mr. Brown of his rights? Yes. When was this? At the doorway. Before he even invited you in? No. It was after he invited us in and approached. He did admit that he had a slot machine. At that point is when we advised him of his rights. This was after we entered, after he invited us in and had taken us to the location where the slot machine was. You say you advised him of the rights after he took you to the location where the slot machine was, after he admitted he had a slot machine, before he took you to where it was? I am not sure. When was Mr. Brown first placed under arrest? After he took us to the slot machine. Did you try the slot machine? No. Did any other officer try it out? No. Did you examine it? Yes. Were you aware that the insides were missing? I was aware that the payoff wheel, or what I referred to as the payoff wheel, was not in there. Did you look in the machine? Just from where I could see right now. That is what I looked at. How close did you approach? Right up to it. Probably a foot in front of it. After Mr. Brown was placed under arrest the first time, did you or any other officer have a conversation with him? Yes. Do you recall the substance of the conversation? Detective Englert, I believe, yes, it was Detective Englert, asked him where the payoff wheel was. He said it was not at that location. And the detective asked him if we could search the location for the rest of the slot machine. And he said yes, we could search the location. Upward pressure up. Uncontrollable expenditures because of the nature of those programs and the nature of the expenses that the states and other providers must endure as a result of inflation and increasing interest rates. One more time. Personally, I am not positive whether there is a great deal to be gained by changing the automatic indexing formula and dissecting its impact on various programs, but still we are obligated to look at that issue and to look at it very closely. The economists who met with our committee in January were almost unanimous in saying that some revision of the Consumer Price Index formula should be made immediately. Of course, this has not been the recommendation of the current administration, but the weight of those recommendations must be considered in light of all other economic and political realities. In fact, in various ways, it is estimated, Mr. President, that 77% of the outlays of the budget for the current fiscal year are not controllable. That is to say, 77% of the outlays are considered to be out of the current control of the Congress or of the administration. Spending associated with entitlement programs explicitly indexed for inflation is estimated to make up 30% of the total budget outlays. The Congressional Budget Office estimates that, without including any more programs under the current automatic indexing, the percent of total budget outlays required by these programs will be almost 33% in 4 years, which is a steady and uncontrollable rise. In addition to the programs that are explicitly indexed, other entitlement programs such as Medicaid and Medicare, which pay for services directly affected by inflation, contribute to the general upward pressure of uncontrollable expenditures because of the nature of those programs and the nature of the expenses that the states and other providers must endure as a result of inflation and increasing interest rates. Even the 23% of the budget that is considered to be relatively controllable is clearly less discretionary than it would appear at first. This relatively controllable portion of the budget includes items such as military and civilian payrolls. The Committee on Appropriations more specifically has within its spending jurisdiction and under its consideration only 60% of the outlays of the total federal budget and of that limited amount, approximately 55% of budget outlays is uncontrollable. The remaining 45% is what can be technically defined as controllable. However, of the 45% considered controllable, 60% is for defense expenditures that are defined as non-mandatory, and 1% is for civilian pay items. The question of whether any budget outlays are controllable by the Committee on Appropriations is a discussion for another time and forum, but obviously in real budget authority, we have some work to do. I and other members of the Appropriations Committee intend to find every economy available in both the proposed supplemental request and previously enacted legislation. However, overestimation as to amounts of money that can be withdrawn without serious consequences to the operation of the government is a serious problem. This is particularly true when we are faced with effectively only 1/4 of the current fiscal year to which rescissions can be applied. Even the 23% of the budget that is considered to be relatively controllable is clearly less discretionary than it would appear at first. This relatively controllable portion of the budget includes items such as military and civilian payrolls. The Committee on Appropriations more specifically has within its spending jurisdiction and under its consideration only 60% of the outlays of the total federal budget, and of that amount approximately 55% of budget outlays is uncontrollable. The remaining 45% is what can be technically defined as controllable. However, of the 45% considered controllable, 60% is for defense expenditures that are defined as non-mandatory, and 1% is for civilian pay items. The question of whether any budget outlays are controllable by the Committee on Appropriations is a discussion for another time and forum. But obviously, in real budget authority, we have some work to do. I and other members of the Appropriations Committee intend to find every economy available in both the proposed supplemental request and previously enacted legislation. However, overestimation as to amounts of money that can be withdrawn without serious consequences to the operation of the government is a serious problem. This is particularly true when we are faced with effectively only 1/4 of the current fiscal year to which rescissions can be applied. Okay, one last time. Even the 23% of the budget that is considered to be relatively controllable is clearly less discretionary than it would appear at first. This relatively controllable portion of the budget includes items such as military and civilian payrolls. The Committee on Appropriations more specifically has within its spending jurisdiction and under its consideration only 60% of the outlays of the total federal budget, and of that limited amount, approximately 55% of budget outlays is uncontrollable. The remaining 45% is what can be technically defined as controllable. However, of the 45% considered controllable, 60% is for defense expenditures that are defined as non-mandatory, and 1% is for civilian pay items. The question of whether any budget outlays are controllable by the Committee on Appropriations is a discussion for another time and forum, but obviously in real budget authority we have some work to do. I and other members of the Appropriations Committee intend to find every economy available in both the proposed supplemental request and previously enacted legislation. However, overestimation as to amounts of money that can be withdrawn without serious consequences to the operation of the government is a serious problem. This is particularly true when we are faced with effectively only 1/4 of the current fiscal year to which rescissions can be applied. Actually, Actually, this is a very important step in enacting the economic recovery program of the President, and one which I am sure members of both parties will support in the final analysis, although details may be adjusted. The Senate Appropriations Committee will now proceed to develop and refine its activities with respect to this budget resolution, and should be able to report to the Senate a rescission bill that will comply with the dates contained in the committee's instruction. That reply, of course, will be to the full Senate. It is my hope, as I am sure it is the chairman's hope, that we will be able to meet the $13.5 billion number contained therein. This rescission effort, however, is just one step in the total budgetary process, for the Budget Committee must now turn its attention to the first concurrent budget resolution, which is an advisory resolution that is only as good as the advice that has been received from all of the various authorizing and appropriations committees. The Budget Committee has scheduled a markup session on that resolution to take place prior to the Easter recess. I encourage them to adhere to that schedule, for they have before that committee detailed information from most of the committees of the Senate, upon which to base their first set of recommendations to the Senate. The March 15 report produced by the Appropriations Committee contains a far more substantive look at the matters under its jurisdiction than previously has been the case. I commend that report to the Budget Committee as a good basis for the recommendations that they will send to the full Senate in the form of the first concurrent budget resolution due in May. Let's try that one again. Actually, this is a very important step in enacting the economic recovery program of the President, and one which I am sure members of both parties will support in the final analysis, although details may be adjusted. The Senate Appropriations Committee will now proceed to develop and refine its activities with respect to this budget resolution, and should be able to report to the Senate a rescission bill that will comply with the dates contained in the committee's instruction. That reply, of course, will be to the full Senate. It is my hope, as I am sure it is the chairman's hope, that we will be able to meet the $13.5 billion number contained therein. This rescission effort, however, is just one step in the total budgetary process, for the Budget Committee must now turn its attention to the first concurrent budget resolution, which is an advice